If you are accused of domestic violence, whether it is through a restraining order or through an arrest, and you are innocent, then at some point you are going to have to likely deal with how to respond to a complete lie. And in this video, I'm going to be giving you a super valuable tip on how to do that not a lot of people realize. My name is Veronica. I'm a domestic violence defense attorney here in California, and I help people put their cases behind them so that they can enjoy their lives and their freedom. I am also the creator of a course called Defeat the DVRO, in which I teach you from start to finish how to represent yourself and win your restraining order hearing. So if that is something that you are interested in, you can get your free first class via the link down below. Okay, so let's jump right in. Let's talk about how to refute just an absolute out of nowhere lie. I'm talking about a situation where the other person says that you, for example, punched them in the face or you strangled them, but nothing like that happened. It's not like you got into a physical altercation and you strangled them to stop them from stabbing you or attacking you in some more serious way. How do you deal with that? That can actually be more difficult to explain than a situation where you did use self-defense, for example. Generally, you are going to want to address the most serious part of the allegation first. So if the other side says that you punched them in the face, or you strangled them, or you whatever they're saying that you did, if it simply didn't happen at all, then say that first. Because if you try to give a story and you're explaining what actually happened, but you don't first deny the most serious part of their allegations, then throughout hearing your story, whoever is listening is going to wonder, okay, but what about the strangling, right? What about the black eye? What about any of that? Are you going to tell me what happened? Do you know what happened? What is your explanation? What is your response to that? What is your side? Okay, so let's go through an example here. Let's say that the petitioner says, on March 1st, 2024, I was looking through the respondent's phone and I found Facebook messages between him and another girl. He caught me going through the phone. He then strangled me. Now, you were the person accused of this. In reality, your side is, well, she did confront me and we did have an argument, but I didn't catch her going through my phone. I also didn't strangle her. There was literally no physical altercation between us at all. And also, this argument took place on March 2nd of 2024, not March 1st. And she did cheat too at other times. I don't know if that's relevant, but she did. Okay, so let's go through some possible ways that you can explain this. And I'll go through the worst example version of this first. All right, so respondent in court says, it wasn't on March 1st, it was on March 2nd. Now note that the judge might actually cut you off at this point because it sounds like you're admitting to something. You are kind of admitting by just addressing the date first that you did strangle her, but it was just on a different date. And a minor detail like that is not going to win you anything. So you can get the date wrong, and if you say that it happened, she's still going to get the restraining order, or you will still get convicted in a criminal case. And if you go on, you say, and she shouldn't have been going through my phone. Isn't that considered abuse? Now notice there that there's no denial of the most important part, right? The strangling. Instead, you're trying to deflect and you're trying to redirect and say that maybe she is abusive. Unless you filed a restraining order against her, then it's not necessarily relevant that she was abusive by snooping through your phone. So that would be basically the worst version of an explanation that you could give. Okay, so let's go through one that might be a little bit better. All right, she started screaming at me after apparently looking through my phone and finding messages with someone else. She was always so jealous and crazy. There wasn't even anything in the messages, and she cheated too. I caught her multiple times. Okay, so notice with that explanation again, there is no denial. If you heard her version of events with the strangling, you were waiting to hear what happened. Was there a strangling? Like, what's her explanation? Is she just flat out lying? Were you defending yourself? So you just aren't focusing on what's important, denying the strangling. And then when you say that someone else cheated too, I'm not saying it can never be relevant in a restraining order hearing, but it's sounding like overall you are kind of angry. Maybe you did strangle her. And the judge only has to agree with the petitioner for restraining order hearings by slightly over 50%. For jury trials and criminal cases, it is beyond a reasonable doubt. But look, if you are going to testify in front of the jury and this is your explanation, you would be better off just not testifying and your lawyer arguing that there is reasonable doubt because the evidence that they have not presented is enough. A good explanation might be, I have never strangled the petitioner. She did confront me around that time, I believe on March 2nd, not March 1st, about Facebook messages that she had found between me and another woman at some prior time. I didn't catch her actually going through my phone. She was very angry with me, which I understand. I mean, obviously I was in the wrong there. I shouldn't have been messaging the other woman, and she was very upset, but I never strangled her. When she confronted me about these messages, I felt terrible. I was apologetic, and I wanted her to stay with me and forgive me, but she never did. So in this explanation, you confront the most important part first and you give the judge your side. Then you explain to the judge this incident that apparently inspired the petitioner to make up this story. You do bring up the date, which is not necessary, but I think it adds a little bit of credibility to just say, yeah, it was on a different date, but you're not hanging your hat on that. And you are also, instead of talking about, oh, well, maybe I cheated, but she cheated too, you are talking about how you know you were in the wrong by talking to this other woman. Maybe you didn't actually cheat, maybe you didn't consider it cheating. You're not even getting into that. You're just saying, yeah, I know I was wrong. And then when you are saying, and I was apologetic and I wanted her to stay with me and forgive me. So if that is actually how you felt, and if you can say that in a way that persuades the judge or the jury that you did feel that way, well, then you wouldn't be strangling her, right? You're not an angry person who's strangling her. You're instead begging for forgiveness. And the last thing you would be doing then is strangling her. I'm not saying that this is perfect, and a lot of it is going to be delivery, how you present yourself in front of a judge, evidence that you have, of course. I hope that you found this video helpful. If you do have a domestic violence case in California, feel free to give me a call. You can find my number down below. You can also book a strategy session with me there about your domestic violence case, whether it is criminal or whether it is a domestic violence restraining order. And if you are planning to represent yourself in your restraining order hearing, get your free class in the course. You have literally nothing to lose. You can get it in the description box down below. If you did find this video helpful, please don't forget to like, subscribe, ring the bell, and follow me on Instagram, TikTok, and Facebook.